Come on, Soda Pop, let's go.
We will now take proponent testimony on House Bill 1196, and I'm going to let the representative read the title again.
House Bill 1196 is an act to create a deadline for the preparation of statements for municipal referendum ballots.
And you just state your name.
Representative Patrick Hirschman, District 15. Good morning, Mr. Chairman and members of the committee. I'm here to support House Bill 1196. 1196 modifies the statute 9-20-13 to allow citizen initiative and referendum groups to the ability to verify the language on a ballot, election ballot, and make changes. The 2014 Sioux Falls Municipal School election featured a full slate of candidates, 3 home rule charter amendments, and 4 citizen-driven initiatives and referendums. As currently written in statutes 9-20-13, a city attorney is the only person allowed to proofread and approve the ballot language prior to the printing of ballots. The petition groups are not allowed to approve the language or the intent of their issues prior to their being printed for voters. The South Dakota Attorney General prepares initiative and referendum ballot language for statewide ballots measures, then are forwarded on to the circulating group. Local government citizens deserve to have the same proofreading and approval process for the rest of South Dakota. House Bill 1196 allows the citizens to view and have corrected the ballot language to be presented on the ballot. House Bill 1196 corrects the current South Dakota election law and administrative rules for all elections, state and local. Thank you.
Thank you, Representative. Further proponent testimony?
Good morning, Mr. Chair and members of the local government committee. Danielson, a resident of Sioux Falls, and here in support of House Bill 1196. In 4 decades of circulating petitions, the standard and proper collection of signatures is to clearly state to the signers, the language you see on this petition is the language you will see on the ballot. It's our oath to the signers. In the 2014 Sioux Falls municipal election, there were 4 citizen ballot measures. These petition drives collected over 27,000 signatures. The attorneys who helped craft the language made it concise to help the signer, voter, and the administration understand the issue. When completed, petitions are presented to the city to prepare the ballot for proper design, form, and function. The carefully crafted petition language is to be used unaltered. This is what the signers gave oath to. Before printing the 2014 municipal election ballots, the City of Sioux Falls did not allow the petitioners to approve the printed versions of their initiative and referendum ballot questions. The citizens of Sioux Falls were given a little green pamphlet that said this is what it's going to look like, but they never allowed any of us citizens to ever look and ever question the process. On each of the ballot issues, the city attorney changed either the wording or meaning of each measure. Our groups had no say in the process. When our groups asked to review the ballots before printing, each was rebuffed. The city attorney had between 6 and 18 months to prepare the ballot language for the petitioners to review and accept. All the petition groups were rebuffed, being told it's only left to the purview of the city attorney. 2 of the election petition issues went to the Second Circuit Court. One before the April 8th, 2014 election, and the other after the vote. The second ballot measure is currently before the South Dakota Supreme Court. Our groups have discovered there is no clause allowing municipal petitioners to approve the ballot language before the printing as state law requires for a statewide ballot measure. In statewide issues, the circulating groups are able to verify the ballot language before the printing of the ballots. South Dakota has a long and strong history with the initiative and referendum process. We ask to have state law changed to require ballot language be approved by the groups collecting the signatures before printing. HB 1196 will simply require all municipal petitioners the same review rights currently afforded statewide petitioners, whatever those dates are required in state law. Thank you.
Thank you. Do we have any other proponent testimony? Do we have any other proponent testimony on House Bill 1196? Seeing none, we'll move into opponent testimony.
Thank you, Mr. Chair, and members of the committee. Jim Hood, once again representing the South Dakota Municipal League. And our concern is the bill as written is going to, I think, screw up our timelines for city elections. And this is laid out in statute. I'm not an expert at municipal elections, but the bill requires that that it be prepared, the statement be prepared and provided to the party submitting the measure no less than 45 days before the ballot is printed. And that is our concern. Every time there's an initiated measure or a referred measure, you know, it seems like the Attorney General and the Secretary of State's office ends up in court by one of the parties who claim they're aggrieved by the statements that have been prepared. And we just think this is going to lead to more litigation now on the municipal election side, and we would, for that reason, ask that you oppose House Bill 1196. I'll stand by for questions.
Okay, do we have any other opponent testimony on House Bill 1196?
Hi, my name is Kia Warren. I'm the Deputy Secretary of State for Election Services. And I just have a handout if the page would. The handout is just a sample timeline. When county auditors, cities, and schools have elections, whether special elections or annual elections, a lot of them call us to try and prepare a timeline for them so we know when they have to have the voter registration deadline notice, when they have to have notice of vacancies published, when absentee voting begins. And so we outline this all in a format for them that they can just put that on their calendar so they hopefully they don't miss any notices. This handout just shows what a sample timeline would be under 1196, not combining with the general election. So a city can combine their special election with the general election according to statute. They can have it, combine it with their annual election or the next general election, whichever occurs first. And so if they would have their first reading on June 22nd, this is the timeline they would follow, including a gap in there to allow that 45 days before absentee ballots are printed. For a city election, they have to have absentee ballots ready and available for absentee voting to start no later than 15 days before the election. If they combine with a general election, we have a federal law that all ballots have to be printed and ready to go absentee voting by 45 days before the election. And so that puts in an additional time frame that they're going to have to try and work around on top of this extra 45 days. We have a lot of cities and schools and even county special election ballots that have been combined with the general ballot over past years, and we've not had any issues with those meeting those timelines without having that 45-day in there. And so we just have concerns on trying to calculate a timeline for a city to combine with the general election meeting, pushing all this out, because it takes about 2 weeks prior to the auditor to prepare ballots before the September 21st deadline to have ballots ready. It takes a few weeks for the auditor to get everything set up, proofread, get it back from the vendor in Minnesota that who prints all the optical scan ballots for our primary and general elections. It takes about 2 weeks for that whole process. So once they send their ballots through our total vote system to the vendor will create templates and send them back to be approved, and then they have to sign off on them. Then the ballots are printed and batched into groups of like 50 or 75 ballots each, and then they're shipped to the county auditor. And so we have to consider all that extra time frame that goes into place for a county if a city wants to combine with that election. So I will stand by for any questions.
Thank you. Do we have any other opponent testimony? Any other opponent testimony in House Bill 1196? Seeing none, I will offer a short rebuttal.
Bruce Danielson, Sioux Falls. The bill was an attempt, and hopefully still is an attempt, to correct an issue, to allow the local residents some kind of a time frame, being that many of these petition drives that go through take weeks, or, you know, in our situation, the referral is a 20-day window. We put everything together. It's sent on through. Since we can't get any help from the city attorney to write these petitions, we have to go out and get the work done. So if the city attorney wants to write a ballot explanation after we've gone through 6 months or 20 days, depending on what type of an issue it is, we want to be able to go back and look at the language that's going to go on the ballot in a timely fashion. In our situations, we've had between 6 months and 18 months for the ability for them to craft an explanation, and then we could come to an agreement on it, and then we're fine. But all we wanted to do was make sure that what was put on the ballot was not a marketing program, or they changed the language. In the one situation, they changed the date. So there was a completion date issued that we finally got a chance to go to the hearing to try and get that corrected. And that's all we're asking, is to make sure that a typo didn't get put in that totally changed the meaning of what the vote was for. And we keep running into this issue in Sioux Falls because we don't have this ability. Because it's a home rule charter community, they think that they can just do everything, and the law didn't allow for any municipality challenge to be able to be pursued. And I understand what Mr. Hood is saying when he talks about having written as a city attorney these explanations, and I'm not deriding anybody in particular in this, but we've been finding issues and problems, and we want to make sure that the paperwork is done properly, the issues are laid out as we went through all of this work. And, you know, we essentially sign an oath that says that all of these signatures on this sheet of paper are correct signatures for this particular issue, and then when it goes to the vote, the city attorney has now made all of us that have taken these oaths and signed our names to be, you know, less than truthful. You know, we want to see what we work so hard for put on the ballot. And if there's some issues on date issues, as I've talked to Secretary of State's office and everybody else in this whole process, we want to follow state law. We want to follow the example that the Attorney General has worked with the Secretary of State's office since 1912 with the initiative and the referendum process. There is a simple explanation process so that nobody can go into a ballot box or go into the voting booth and see a last-minute marketing pitch for one side or the other. Thank you.
Thank you. And I'll open it up for committee questions at this time. Representative Soley?
Thank you. I have a question of Ms. Warner.
Chair, can I answer that?
Thank you. Thank you for being here to testify on this, because it's helpful to us as we think about it. On the bill, there's the one line that refers to the 45 days. It says the statement shall be prepared and provided to the party submitting the measure, and then it says no less than 45 days before the ballot is printed. Is there a way we could change that sentence so we wouldn't mess up the timeline? I understand that in cities and counties and so on, there's going to be different schedules, and they're, especially if we're going to join in with that November election under your direction, that we need to be aware of that. However, it seems to me that this is a reasonable request. I know you've explained to me personally how much care the Secretary of State's office takes to make sure the different sides of the ballot measures are represented. And it seems to me that we should be able to do it. So is there a way to do this if we took the 45 days out and put, say, in a timely manner? Is there a way to do this that would make this acceptable to the Secretary of State?
Mr. Chair? There is a statute in law that requires cities to certify ballot language to an auditor no later than August 9th to combine with the general election. And so that's kind of their cutoff date, and it's gonna always depend on when they have that first reading on that ballot measure, whether they'll even be able to combine with the general election. If they have a first reading, probably like in March, then it says, the law says you'll have to combine with your annual election or the general, whichever occurs first. And so it gets kind of in a crunch time when you're looking at something that might be a first reading in like May or June, because of the deadlines the auditor has to follow and all the extra publications that have to go in from the city, where they have to publish the first, the readings and wait 20 days for a referral process. All that takes in more time than what statewide ballot measures do, because that process is done way ahead of time. And so if they would change, the 45 days works if they're just gonna have it on their own election, like a special election. But we see the difficulty when it's combined with a county auditor on the general. So if they were gonna change the time frame, I guess I'd have to go back and try and create a timeline to see what that best time frame would be.
Thank you.
Further questions from the committee? Seeing no further questions, I will close the public hearing portion on House Bill 1196 and ask if there is any discussion and or action.
Mr. Chair,
Representative Rosen.
I move to 41st day.
We have a motion to move House Bill 1196 to the 41st day by Representative Rosen, second by Representative Conzett. Do we have any comments on that?
Just briefly, I think for this to happen, it would have to be worked very carefully through the Secretary of State's office. From a municipal point of view, elections are very expensive, so you always want to combine with another election if you possibly can. So it's not just the municipal election. This really needs to be honed to a point of, I think, involving everything, and particularly when you start looking at what happens with our military and the overseas ballot. So this needs a whole lot more work, I think, to make it work.
Any further discussion, Representative Soley?
Thank you. I really am supportive of the idea behind this. I think on a municipal level or county level that we need to make sure that the parties submitting the measure have a chance to look at, just as we do on the statewide level. However, I understand the timeline issues. I would agree with the previous speaker that this would need some real fine tuning before it could, we could vote for it, and the timing part of it is going to be important, but I'd like to be glad to see it back in a different form, but at this point we'll have to say no.
Any further discussion on the motion at hand? Seeing none, we have a motion to send House Bill 1196 to the 41st day, first by Representative Rosen, second by Representative Conzett. All those in favor will say aye. Those opposed, nay. The secretary will call the roll, please.
Representative Brunner.
Aye.
Craig.
Aye.
Greenfield.
Aye.
Hawks.
Aye.
Heineman.
Aye.
Marty.
Aye.
Huang.
Aye.
Rosen.
Aye.
Shanefish.
Aye.
Soley. Tulson. Otten.
Aye.
Consit. The vote is 13 aye, 0 nay.
By a vote 13-0, House Bill 1196 be sent to the 41st day. Just one quick little comment here before we go. I'd like to thank Bruce Danielson for taking his time to come up and testify today in front of this committee, provide his input. It wasn't an accessible day, but thanks for coming up and exercising your right. At this time, is there any questions or comments for the good of the committee? If not, a motion to adjourn.
Second.
Second. I have motion adjourned by Representative Craig, second by Representative Marty. Those in favor, say aye. Aye. Those opposed? We are adjourned.
Y'all come back now. Here.